For quite a few years now, I've been involved in investigating and trying to improve the way that language evidence is used and understood in determination of the claims of some asylum seekers, both in the UK and also around the world. My approach to this has not been as an advocate for asylum seekers, or indeed to help governments, but really as an advocate for linguistics, my field. So I've been involved in three ways. The first step, nearly 10 years ago, was to seek agreement from linguists internationally to see if we could agree on a set of minimum basic standards based on what we know within the profession for the use of language evidence that would provide a level playing field. And we managed to do that, to publish a set of guidelines aimed at government, immigration and asylum bureaus, lawyers and courts. And that has been used and cited in thousands of cases around the world. The second step has been to assemble an international group of experts in order to see if we can agree on best practice, investigate the process further, and then try to get best practices accepted and implemented in various countries. We started the Language and Asylum Research Group 3 years ago. It's based at Essex, although it's international in scope, and it draws heavily on the experience and the knowledge of colleagues here, such as Jeff Gilbert in law, the former HRC director, John Packer, Renos Papadopoulos, who is also the founder and director of the Center for Trauma, Asylum and Refugees, not to mention my linguist colleagues, Anama Aware and Monica Schmidt. The Human Rights Center's prestige and spirit of collaboration and openness to practice has really been essential to getting this going and has allowed us to bring in international experts from around the world as well. The third strand of work that I've been engaged in has been focused in the UK since 2008. I've written over 60 expert linguistic reports for appeals of asylum cases that have been turned down, partly on the basis of language. Last July, there was a decision in the Scottish Court of Sessions, their Court of Appeals, based on a case that I advised on, which set a new and much higher bar for the use of language evidence in asylum cases. This Scottish standard is much higher than what's currently the case in England and Wales. So there's a clash in the law right now as to how to interpret language evidence for asylum seekers. We certainly hope for a resolution between the current conflict between English and Scottish law, but more than that, we're looking forward to the future of this work. Training of analysts, training of governments who commission this work would be an ideal thing to have in place across Europe.